Welcome to another episode of Unraveling Intellectual Property with Michael Stein. Today, I'm excited to have a current fraternity brother of mine from college, Joel Nied. Welcome.
Mike, great to see you as always.
So let me give a little bio and then we'll get into the actual podcast. So Mr. Nied focuses his practice on corporate and securities, mergers and acquisitions, debt and equity financing, and intellectual property. His practice includes representing clients in matters relating to contracts, securities regulation, blue sky law, and private placements. Mr. Nied also has extensive experience handling transactions involving joint ventures, fund formation, licensing agreements, engineering services contracts, and developing and supply agreements, which is all extremely impressive. And today,
and Mike, you make it reality. It is kind of exciting. It's interesting stuff.
Okay, well, great. Today, we're going to be talking about what companies need to have with respect to lining up their intellectual property, whether they're going to just keep their intellectual property or looking to buy or looking to sell their companies, and Joel's an expert in this area. The first question I'd like to ask Joel is whether you're just looking to hold your IP or you're looking to sell your company, what issues from an owner or seller's point of view do you need to consider?
Mike, it's a great question. And, let's approach this whole issue with the concept of, the creation, ownership, and monetization of intellectual property. There's, people are in business, and, sort of one of two things is going to happen with creating value out of intellectual property. One is it's going to be incorporated into an operating company, and that company's either going to create revenue or it's going to be sold. Sometimes people describe businesses as marriages. Marriages can last sort of forever, and we hope they all do. Businesses are going to come to an end, typically, or at least an individual's participation in it will. So you've got people who are founders of companies. They're either going to cash out by selling their ownership, whether it's when they retire in 30 years or hopefully less, or when they sell the business, or they're just going to make money over time. And you need a plan for all these things in the beginning. So sometimes people sign prenups because they hope their marriage won't end, but it may, and they want to be prepared for that. But with regard to intellectual property, you have to obtain it and create it with the assumption that there's going to be an end point in your relationship with it. And so it's best you plan for that now. So you can look at ownership issues of intellectual property, relative to life cycle events of a company. So there's the creation of the company, the growth of a company, whether that growth is organic or by acquisition, and then the sale of the company. And if you look at all those points and what the potential outcomes are, you want to plan for those outcomes at the beginning. So some examples are, if a group of people or one person decides to form a company, who owns the intellectual property they're bringing to the table?
One of the biggest issues with respect to intellectual property is the ownership issues. And so, please.
Right. And those issues come into play. They're not in the abstract, because if you've got somebody who is signing up for a company and they've got a partner, and the partner says, I'm bringing all this IP in, you should ask, well, who owns this IP? Does my co-founder own it, or does the company that I'm putting money or time or effort into own it? In those situations, typically you want the company to own it. So you've got to document that ownership. It doesn't happen automatically. Or if you hire an employee and the employee begins working at the company and developing intellectual property, whether it's code or whether it's trade secrets or a patent, these are all sort of fall into different buckets, as Mike can explain better than I can, of copyrights, trade secrets, patentable, material, and how you safeguard against that. Who owns it? because a patent is great and it provides significant protection, but you have to have an inventor, and the inventor has to be obligated, you want to assign it to the owner of the patent.
Yeah, and I'm guessing as part of what you're doing when you're advising a company is advising them on such issues.
Yeah, exactly. So, for an example, when, people are starting up a company, you want them to assign that intellectual property over. And there can be economic or tax benefits in the way you do that. So it's not just an idea of, well, who owns it, but also, how do we do this in a tax efficient manner? So those are some things.
Let's look at it from the other side. Let's say I am a buyer. I'm considering buying a company.
Right.
What are the types of things that I need to look out for when I'm buying a company? And of course, intellectual property is a component of what you're getting and how much a company is worth.
Yeah, 100%. So, depending on the company, the IP can be either a significant amount of the value, or it can be an, ancillary component, but can end up causing you a lot of trouble, after you buy it. So, if you're buying a company, you need to pay attention to those things, and keep in mind, let's talk, Mike, about buying in a larger scope, because you could be an investor, you could be someone who's buying the entire company, and in all those situations, you want to know who owns the intellectual property. So this is it's really important to look into that. So how do you and it's sort of the same side of the coin as the seller, because imagine you are the seller of a business, you want to make sure everything is lined up, so that when you are offering your company for sale, it's like a nice polished apple, right, Mike? I mean, if you're at the grocery store and you're looking at two apples, you're gonna look at the one that,
I've never heard that analogy, but it's good. Yeah, I'm gonna go with the one without the dings on it.
Exactly. So, and you know what? I mean, the one with the dings on it, may not have any worms, and the one that's shiny, may have the worms, but, and that will come out eventually. But at first look, you don't want to turn people off and say, I'm not interested. And that can often happen, when you're a buyer, and it's a bias that you have to overcome, but certainly when you're a seller, is that when a buyer says, as a buyer, you want to look for this, hey, show me, the sort of the chain of ownership. How do I know who owns, this code or this patent or your trade secrets or whatever? As a buyer, you want to see that information. You want to see IP assignments from the founders. You want to see employment agreements, although.
Yeah, I would think like the employment agreements, because employees all the time say, hey, I did that on my own time or using my own equipment. And so you want to see, you want to make sure that employees aren't going to jump in and say, well, I really own that.
Right. And in general, there's, and Mike can talk about this more than I can, the work for hire doctrine, which applies to employees, which typically says if an employee creates intellectual property, without any other action, it's owned by the employer. Although it's great if you're the buyer and you can see a confidentiality and intellectual property assignment agreement, gives you a lot more comfort, as opposed to just relying on the common law notion of oh, don't worry, the employer owns it. Independent contractors, very different situation. And we all know these days, companies hire independent contractors. There's a whole other issue about whether those independent contractors should be categorized as employees. But I guarantee you, if there's an independent contractor who created intellectual property and the company's being sold, they're going to say at the time, forget me asking for compliance with the wage laws. I own the intellectual property that I created. I'd like to be categorized as an independent contractor. And the work for hire doctrine doesn't work the same way it does with employees. There has to be a written agreement where the independent contractor assigns the intellectual property to the employer, or whatever you want to call the person who hires the independent contractor. Otherwise, you end up with just a license as opposed to ownership, and the independent contractor maintains it. So as the buyer, you want to look for all these things. You want to look for the initial assignment of any IP that was created prior to closing but was contributed to the employer or the company, excuse me. You want to see employment agreements or the intellectual property assignment agreements for the employees. You want to see the assignments from independent contractors. You want to see all those things. That doesn't even get into licenses, but that deals with
All right, we'll get that in. Well, let's get that in the next section.
Okay, you got it, you got it. So we'll talk about employees and organically created. I guess that's the best way to describe it, intellectual property. So all these things are what a buyer is looking for. And then, of course, the buyer has to do, that's just one threshold. The buyer then has to do due diligence, on its own, but also rely on, representations from the seller that they own it, that they're not infringing on anyone else's intellectual property, because as we all know, you can have a patent application, which doesn't mean much until it's granted, and even patents. And again, Mike, this is your area of expertise, not mine, but even patents can be invalidated. And you want to have, good understanding. And then, depending on the industry, there can be more issues.
All right. So let's take one thing at a time.
Yes.
I mean, you mentioned briefly about licensing. So let's get into the licensing from both, again, or even if you're not even selling the company, but you just want to license your intellectual property. So we'll look at it from the owner / seller, and we'll look at it from someone who's potentially buying, and maybe they're buying something that's already licensed and they can't just cut off the license to a third party. Yeah.
So licenses are, I mean, let's talk about some basic terms, right? So there's, inbound licensing where you are you're asking somebody else who owns the intellectual property for you want to have the right to use it. And then there's outbound, which you've created something and you want to give other people you want to monetize it. You want to charge other people for using your intellectual property. And all of these things can get pretty complicated pretty quickly. There's
that's why they need to hire people like you, right? If anyone can do it,
and you, Mike.
Of course, and they need me as well, of course.
Right. So I help people. I don't help people create the intellectual property. That's something Mike does. But I help people monetize it. So once they say, I've got a patent or I've got other intellectual property and I want to make money off of it, then I can help them with the assistance of people like Mike to make money off of it or to use somebody else's intellectual property. And, some of these, the term license can, is sort of or a license can span a spectrum from having very limited rights to use intellectual property all the way to something that really resembles ownership. And those distinctions can cause issues with tax purposes and, and other things. So it's, important to pay attention. It becomes a multifaceted issue if you're going really from one extreme to the other, or, it's sort of on the extremes of those issues. But typically a license is, a right to use intellectual property, and sometimes there's restrictions on geographic scope or use. So you can have something that's limited to the, consumer electronics industry, but not to, manufacturing. And so there's a lot of ways to slice it. There can be exclusive, non-exclusive licenses, and you can license pretty much any type of intellectual property. So they can take a lot of forms. And they can, whether inbound or outbound, the compensation, for them can, again, take a lot of forms. There can be an upfront one-time payment. There can be royalties that are based on use or time. There can be minimums. And then you can have the same issue with, exclusivity issues that can be exclusive in some regions, categories, certain period of time. If you don't pay enough in royalties and you're the one that's licensing it, you can say, well, if you're the licensor, you may say, well, I'll make it exclusive as long as you pay me X amount. But if you don't, then it becomes non-exclusive. So there's a lot of issues. But when you're looking at it from the perspective of acquisition or sale of a company, both inbound and outbound licenses have issues that you need to be aware of. And again, you want to try to plan for those in advance, which sometimes becomes complicated because you have your interest as the company that may sell, but also the licensor or licensee has their own interest. So if you are the licensee of a great piece of intellectual property that is essential to your business, then if obviously you want a long-term license, You want the right to renew it whenever you want, or the right to cancel whenever you want. And you also want the right to assign that license so that if your company is sold, the assets may be sold, or the stock may be sold under all circumstances, you want to be able to assign that to whoever receives it. Now, the licensor may say, no, they're probably pushing for a shorter term license. They probably
Or maybe like a non-exclusive versus exclusive license.
Yeah, exactly. Or they may make it non-exclusive if you assign it, or they may want to have the right to, or they may want to prohibit you from assigning it. And often these are totally legitimate reasons, right? I mean, no one who owns intellectual property wants it assigned to a competitor or a potential competitor. So they may want to know, and that's often an issue that comes into play. So these are competing interests, right? And again, from a buyer's perspective, you may want the right to terminate a license that you buy as part of a pool of assets, or you may want the license to last a long time. And sometimes in an acquisition, during the process, you may have to renegotiate the license with the buyer, the licensor, if they have the right to terminate it on assignment. So these are all things a buyer needs to look out for. These are things a potential seller or just the person who has a license, who's the licensee, the inbound beneficiary of a license, needs to consider when they're signing the license. So it's always important to think in the long term, what's going to happen 5-10 years from now. Even if I just need this license for 5 years, the IP may become sort of irrelevant at that point, or outdated, but I may sell the company in 3 years, and I want to be able to assign this license for the 2 years after that. So these are all factors.
And then, sorry to interrupt, but
Yep.
in the the licenses, that's state law, right, versus federal law? Or does federal law?
Well, typically it's contract law, right? So it's which is state law, and these days there's a lot of license deals that span continents and countries. But typically it's based on just contract. And so those are the things you need to look out for. Right now, the creation of the intellectual property that's licensed is governed by federal law generally, not always. I mean, there's trade secret issues, but copyright and trademark, and patent. But so there's a certain interplay of that. But you're right. In general, license deals are strictly contractual. It's between the parties. You're right. State law governs, but even I wouldn't say superseding state law. Everything's subject to the common law or statute, but it is really whatever the parties negotiate without sort of some law or regulation coming into play. Now, that's not always the case, for example, with intellectual property generated through a federal contract. There may be.
I think that could be a whole other issue, right?
It could, and I don't
know if we want to get into all that detail, because what is that by dole and
yeah, and I certainly do not want to.
Right.
Part of my job is to flag issues,
Right.
and a government contracting intellectual property issue is something that is not my area of expertise, but I know enough to ask the question. And it is an important question to ask. So if you've got a company that's a government contractor, or you're licensing IP from the government, those, forget state law, federal law, the federal acquisition regulations can come into play, and that is something to be aware of and address whenever you're in that situation. That's for sure.
So far, I'm learning a lot. I know some of this stuff, especially relating to the patents, but a lot of stuff to consider. But let's get into the infringement issues. And of course, if you're a buyer, you don't want to be buying into a company that could be subject to a patent or trademark infringement lawsuit. So what can the buyer do to protect themselves?
Yeah, so this can get, as you can imagine, pretty complicated. I mean,
do you have anything simple for me?
No, I do not. Things as as Mike said at the beginning when he introduced me, we are college friends, and things were a lot simpler back then. But things have gotten more complicated, especially when you're dealing with intellectual property, and even frankly, even more so when you're dealing with the purchase of a company that has intellectual property, or just buying the intellectual property itself. And so you get into these issues, right? So you own. You're a seller, you own intellectual property, everything is going great, you've got a patent, or you've got some software code, it's fantastic, everything's working well. And by software code, I know people, that is embodied in an app or software or SaaS. Things are going great. Now, is your intellectual property infringing on someone else's intellectual property? Well, how do you know? I mean, when somebody says you are, right? I mean, there's unfortunately no mechanism to there's no great mechanism. Now, you can do patent searches, and you can do trademark searches, and that is Mike's area of expertise, and he can give guidance. Although I think he'll tell you, I mean, my sense is, and I think it's the right sense, is you can never be perfect with these patent and trademark searches.
You can give probabilities, likelihood, but nothing guaranteed.
And tragically these days, you can never prevent someone from suing you, even if you've gotten sound advice on whether there's been intellectual property infringement, or might be, or someone may or may not sue you. So it's an imprecise science, but it's useful to do these sorts of things, because they reduce or at least they point out obvious issues, or maybe less than obvious issues, or risks. But it's a problematic issue whenever you're dealing with someone who's developing IP that with the goal of sort of selling it, or even licensing it, and whether you're selling the asset or licensing the asset. And then it's also, the buyer is, to a certain extent, you're holding your breath and hoping for the best. Now, you can mitigate those risks. One way, as we discussed, is doing a search. So as a buyer, you may want to do a patent infringement search and a trademark and copyright search to see if there's anything blatant out there, obvious out there. And then, of course, as a buyer, you can ask the seller, has anyone ever sued you? Have you gotten any letters to, and then there is the risk allocation concept.
Okay.
And the risk allocation concept is, if you're the buyer, in a perfect world, you tell the seller, I want you to represent and safeguard me if after I buy your IP, I am sued or threatened for for infringement or suffer any damages. And the seller will say, how am I supposed to know? I can't represent to you, it will never infringe. And the buyer says, well, we just need to allocate that risk. So who should bear the brunt of a lawsuit? Should it be the seller or the buyer? And now, depending who I'm representing, I guess I can make an argument either way. But that's
all part of the negotiation process.
I'm not going to say who's right, but and the arguments, the argument from the buyer is, well, we didn't make it, and you've got a better sense than we do. And the seller says, well, look, I all I can tell you is that nothing's happened so far.
Well, but I mean, also getting into, the seller, kind of like a house, you want to just sell the house, you want to be done with it, especially, you're coming to,
correct.
You don't want to be, 5 years later, the buyer says, oh, I've been sued, and
right, exactly, right, and the buyer can say, the seller can say, well, look, you've priced in the risk, right? That's why you're worth more. So you've already priced it in, so there's all these issues that come into play with intellectual property, and the same thing. Forget sale of a business. Imagine if you are the licensor or licensee. A licensee is going to say the same thing. Hey, I'm paying you for this. If I get sued because your IP infringes on somebody else's IP and I get sued, that's totally not my fault. There's a much stronger argument there, right? Because they're like, hey, I want you to indemnify me if I get sued. Now, of course, the licensor says, doesn't want to do that, and says, well, how am I supposed to know? And you can terminate this license if there is an infringement suit, and it turns out there's infringement, so you don't have to pay us any more royalties. So there's all this interplay, but it's an important issue, and it's difficult to assess the risk, candidly. I mean, you can but how do you mitigate it, right?
Right. Yeah.
So one is to negotiate who's going to bear the risk. That's one. The other is, and this gets into the government contractor issue again. You can ask the seller, and you can ask to provide an opinion that says, based on the federal regulations, we believe that the seller owns this intellectual property, and that provides some comfort. But at the end of the day, it's just a letter from an attorney, and we all know what attorney letters are worth. So what attorneys say is worth. But those are some of the things you can do. What else can you do? Well, you can mitigate. A buyer can mitigate, and frankly, a seller does. And we'll get into this in a second. A buyer can mitigate the risks the same way they can against any of the other risks, whether it's environmental, employee issues, general litigation issues, all these sorts of things that can come up post-closing in an acquisition, and you can hold money back from the sale. So if you're paying $10 million or $100 million for a business, you can say, well, let's put $1 million or $10 million aside and hold that there for a year and a half, because 2 years, whatever, because chances are if there's a dispute, it'll come to light before then. And if there is, we have to get indemnified, we'll take the money out of that. That's one way. Another is something called reps and warranty insurance, where you ask a third party to bear that risk. So it's basically an insurance policy that you pay a premium for. It's going to result in the insurance company doing some research on their own, which is fine, right? It's a third party. And so that if there is a breach of this representation, that there has been no infringement, then the insurance company pays out. As opposed to the seller or the buyer, worrying about whether the seller, will be around to pay it out. So
I guess part of the premiums is how litigious that industry is.
Correct.
And I'm sure, like every other type of insurance, a whole host of factors.
That's right. They've got their, they've got their adjusters and accountants who figure out what the premium should be. But often it's incredibly cost effective, and it just eliminates a lot of the back and forth that often goes on, in negotiating these issues. So it can be a very effective way to streamline, the negotiation.
We've covered a lot of stuff here, a lot for even me to digest, and I'm sure everyone out there. But do you have any, parting comments based on what we've discussed to wrap this up?
Yeah, I mean, I know everything's I kind of describe my job as not the emergency room surgeon like some attorneys are, some litigators are, but more like the guy in the body shop, right? So sometimes I see someone with a banged up fender and help them out with that, but often it's bolting a nice spoiler onto the car to make things better. So you should think about advisors like Mike and me as people who are enhancing things, right? Our job is to, make you money, reduce your risk, or safeguard against losses, and seek guidance earlier. I would much rather have a conversation, 5-10 minute conversation, flagging issues or telling people to, fill out a form document than I would trying to backfill 2 months before a closing.
I tell clients, all the time, it's going to be cheaper for you to get me involved earlier than me to fix the problem because you thought you could do it on your own.
Yeah, exactly. And just also, the most precarious time, I think, for a company and involving IP is at the beginning. Things are moving fast. Somebody joins the company and then leaves the company. You may have issued them stock and you may not have. They may have signed documents, they may not have. And none of that comes to light until there's a significant event, a funding event, a sale, and everyone realizes, oh, Jim, our fraternity brother, who was here at the very beginning and left after 2 months when he got a job that actually paid a salary. Did he create anything? And how do we track him down now? You do not want to be in that situation. So that's really the most precarious point.
Well, I appreciate you coming on my podcast. Why don't you tell us where you work, contact information? I'm also going to post it when we do post-production and that, but.
Sure. So I cut my teeth at some of the biggest firms in this country, realize I like working with smaller clients, and I'm at a smaller firm that's still a decent size. It's based in DC. It's called Price Benowitz. We've got offices up and down the East Coast and a couple in the Midwest. And I would love to spell out my name, but everyone gets it wrong whenever I do that. And Mike, I guess you can just post my email address and my name, and
Yeah.
people can get it.
Well, that's Nied, Nied.
That's correct. There you go.
Right. Well, I think we already discussed, we're going to have you back in a future episode to discuss venture capital, how to raise money, how to go public, and how to make yourself desirable for that sale. Again, thank you to all our viewers. Thank you for tuning into this episode of Unraveling Intellectual Property with Michael Stein, and see you soon.